So Benjamin Perrin's time in the witness box is done. The trial resumes on Monday. For now, though, let's turn to Solomon Friedman on the legal significance of Perrin's testimony. He is a criminal defense lawyer in Ottawa. So, Solomon, let's first talk about this whole week has really been about that deal for Mike Duffy, and how well do you think the Crown is making its case against the senator?
You know, really a spellbinding week in, what is ordinarily sometimes a pretty boring place, the Ottawa courthouse, where people got a glimpse behind the scenes at what goes on at the highest levels of decision-making in the Prime Minister's office. But at the end of the day, this trial is not about politics. It's about whether or not the Crown has proven their case beyond a reasonable doubt. And I think to all observers, the picture that Defense Counsel Don Bain has very skillfully painted is one where the scheme with regards to the $90,000 was not something that Duffy forced on anyone, but rather was something done at the insistence of the Prime Minister's office to insulate the PMO and the government from political damage. So, it's really been a back and forth there, but Don Bain seemed to emerge today victorious with his narrative carrying the day.
So we definitely heard some dramatic testimony this week. Perrin says that he clearly remembers that Ray Novak was in on the discussion about that $90,000 check. Nigel Wright didn't recall. So what does this discrepancy mean in terms of the criminal charges against Mike Duffy to have what seems to be some contradictory testimony?
Well, I think people need to remember that whether or not Novak was in the room is a very interesting issue politically, but really has very little to do with the Crown's case. So, observers, of course, have fixated on it because it brings this issue closer and closer to the Prime Minister and to his current staff, but it has very little to do with, whether or not the Crown can prove their case. I would say this as a criminal defense lawyer, I don't find it at all surprising that two people, even if they are both doing their best to be honest and credible witnesses, there will be discrepancies in their evidence, especially about conversations that happened a year and a half ago. I tell my clients when we're talking about testifying, I say, look, can you remember clearly a conversation you had yesterday, word for word, or even a week ago, never mind a year and a half ago. So people do come there, but at the end of the day, all we have is really the frailty of human memory.
And so, it's interesting that you mentioned that because you're right. What matters politically and what matters legally seem to be merging, and it's hard to kind of separate the two. I thought it was interesting today that the Liberals are saying that they want the RCMP and the Information Commissioner to investigate the role of Harper's staff, and they say that this comes from Liberal MP Dominic LeBlanc. It says that they respectfully request that you, the RCMP, investigate potential pins, text messages, BlackBerry messages sent and received by Ray Novak and ensure their preservation as possible evidence relevant to these criminal proceedings. What do you make of that? Is that just political posturing, or do you think from a legal point of view that is important, that some of those messages be preserved?
I have no doubt, having seen the information to obtain that supported the search warrants and production orders in this case, that the RCMP have combed through all of that. What is really important legally is a simple question. If Novak, Wright, Perrin all arranged this scheme, which is allegedly the subject of criminal charge with respect to Mike Duffy, why have they not been charged? And that is a question that Mike Duffy's lawyer has put front and center. None of these people have been charged. In our law, if you assist an individual in committing a criminal act, or if you encourage it, that's what we call aiding and abetting, you are a party to the offense. So how can the people arranging the alleged bribe not be charged, but the person who receives it be charged? And of course, that is a live question. There are answers to that question, but that's the real salient issue from a legal perspective.
So why do you think?
Well, the police have discretion to charge or not charge, and the Crown has discretion not to proceed with charges. In certain cases, in the more common criminal context, we see all the time where they'll, make deals with the smaller fish or lay off the smaller fish to get to the bigger fish, to get information about somebody who they believe has more moral culpability. They'll do that in both a formal and informal way. Now, the other issue here is whether or not Duffy is charged with soliciting a bribe. That is, the offense that's being charged is him requesting all of it. And, if that's the case, then he's the only party to the offense, not the people who arranged it. Most importantly, though, here was the point that Don Bain underscored with Benjamin Perrin at the end of his testimony. He said to him, "You did not believe there was anything illegal or unethical about this." Benjamin Perrin agreed. "And you never would have assisted him had you believed there was anything illegal." So if a government lawyer, the most senior legal advisor to the Prime Minister of Canada, said, "I saw nothing illegal about this deal," how is Mike Duffy supposed to have the criminal intent required for a conviction?
So what do you think? Do you think that, as you say, that Benjamin Perrin didn't think that there was anything illegal going on? From what we've heard so far, as a lawyer yourself, what do you think?
Well, I think it is going to be a tough road for the Crown to establish criminal liability in a case where, Mike Duffy himself was represented by very able, very senior counsel. This was negotiated at the highest level. How come he is the only one left holding the bag? That's going to be his question. Now, of course, the Crown, their view is, it doesn't matter whether or not you knew what you were doing was illegal. It depends, did you intend to commit this act? And if you intended to do it, ignorance of the law is no defense. It's a very basic principle. It's enshrined in the Criminal Code of Canada. So simply saying, I didn't know it was illegal, that's not good enough. This is going to be a very close call when it comes to this $90,000 check that ultimately will be in the hands of Justice Valancourt.
Great to talk to you, Solomon. Thank you very much.
My pleasure.
And that's criminal defense lawyer Solomon Friedman speaking to us from Ottawa. You're watching CBC News Network. We're back in 90 seconds.